Так, есть предложение.
Well, why don't we take our seats? Coffee break should be over. Are all our panelists available? Well, we have fewer people than we had before the coffee break, which is not to say we are not going to discuss. I'm giving the floor to Tatiana Nikolaevna Neshataeva, Doctor of Law, Professor, Vice President of the Court of Eurasian Economic Community. Well, you see, colleagues, some colleagues have left. That was done on purpose because two presentations were against the court, and my talk will comprise 5 parts: preamble, philosophy, documents, practice, and if we have some time left, then a PS, the staff. In 2011, before we all heard what would happen, I was approached to draft the statute, international statute, and privileges and immunities. I decided to recall my youth. That was my candidates and doctors' thesis. I thought supranationalism prescribing for Russia in a strict way. Well, in Russia, supranationalism has always been disdained. I had a negative opinion to my doctor's thesis from the Ministry of Foreign Affairs and the Moscow Institute of Foreign Relations, and several other negative opinions. So I thought it just wild that we could have supranationalism. And of course, I went at large. I sent the draft in. Then the supranational court started to operate, and it's been in operation for 3 years now. It operates as a supranational court exclusively with legal entities. You heard what it was, that it was not in place and that it would only appear in the future. No, it is not. It's been in place. It's been around for 3 years now. Then I forgot about the documents because there was a new. I was again approached to draft the regulations for Strasbourg. That's what I'm working on, and I'm going to finish by January 2015. I understood that supranationalism has no way forward in this country. But you know what? When I saw the final version, my first instinct was to weep, because it had been accepted by 90%. Only 3 nasty things were included there that go contrary to the general international law and contrary to our WTO commitments. One is very dangerous there. 2 others are easier to overcome. The authors of those nasty things are gone from this room, as you see for yourselves. So whatever you are told, there had been a very harsh fight between the 2 trends, and the fight is not over yet. The intergovernmental organization or a supranational organization? What kind of organization fits well the integration? Theoretically, we do understand that none of intergovernmental organizations ever resulted in integration. Intergovernmental organization is good to have a chat, have a meeting, and then over a glass of tea you can discuss some future draft document. Whether or not the draft materializes is never known. A supranational organization, even if it has a very small supranational element like the WTO, that is a very successful operation indeed. Actual work, actual relationships. Obviously, when the draft was being worked on, there was a fight between the 2 trends. What we're going to be, still an intergovernmental organization with very wide functions of national governments and presidents, or we would delegate part of the sovereignty. So whatever people say, because the norms that hinder these norms go contrary to international law and will never work. The documents themselves are documents that are very good and powerful for a good, powerful supranational organization. In some elements, they are even better than the EU has. However, why? Because we had taken into account the main mistakes made by the EU. I do understand that the work is not going to be easy next, because these two factors, we delegate in part of the sovereign competence, or whether we keep to it, I'm a national official, everything is mine, or another option is for the common goal, for the sake of free flow of goods, services, workforce and people for their happy life, so that we have overall integration or not. So these are the two things that are fighting each other. Why I say that there are elements of supranationalism included, I'm going to show them to you. They're left there, even the most fantastic things that I had drafted, knowing or thinking that they would be discarded, but it didn't happen. The first thing, and one thing I wanted to mention, is that literature, they never write it in literature. Only fundamental research would reveal that. Actually, I think that the European Union, the single European space, legal space, had not they were created not by Brussels or councils, but by courts, through common understanding of the common goal. It went through Luxembourg and Strasbourg, because partially it has become part of our lives as well, and we operate with it, and owing to that, our judiciary is more or less getting better. So, most attacked point in the literature from the government officials and elsewhere, and it's been very difficult for me over these 3 years. I used to hear it every day from all around the CERT, because the understanding is that it is the court that can produce the single space. This understanding is what the national governments do know, and they understand it and they fight it because they do understand it. But then it was accepted that the Commission was to conduct the single policy. It can be seen here. It was all taken out of the draft. It was included in the addendum of the committee. Single policy, taking single decisions, single unified normative acts, and explicitly applicable to physical persons and legal entities of the member states. The first sign of supranationalism is a limitation of national sovereignty. People, physical persons, start to be subject to supranational acts of the supranational government, that is Eurasian Commission. These are very narrow things. Customs, trade. I do not understand very well what happens with the IPR, because there was a request on parallel imports. We denied it for a while, and gradual inclusion of those things into the hands of the unified government, away from national governments. The issues that are not within the terms of reference on industry, I understand, and not full agreement has not been reached. They would be within the joint competence, and intergovernmental negotiations have to be held, and you can easily say that most of the issues will never be resolved in the bog of the intergovernmental talks. And the second sign of supranationalism or supranational organization is limitation of the independence in external relations. That is again one other thing over which there was a lot of fight, but it has happened. Since we exceed the WTO individually, member of the same panel, you experts who read the WTO court decisions or read in the WTO cases would know that none of the non-European country like Germany, France or Italy, they act as the EU because of the voting principle and the quotas, and the number of votes strongly depend on whether or not you appeal individually or as a union. Ukraine blocks with Honduras because one voice is not enough. One vote is not enough. And our vote was like fifth or sixth as we walk alone. But if we walk, the three of us, on key groups of goods, we could have the second and third vote and the first vote if we twin with China. So for this structure, it is very important to have another sign, being able to block in external relations, only in the economy. So far, only in the economy, because the fact that the European Union announced politics and social sphere, we see what is going on there. Thanks God we have not made this mistake here. Now let's take up the documents. All the documents that the Eurasian Commission is to adopt. If people do not like it, if a legal entity, if a businessman doesn't like it, they are free to go to court asking to repeal it, be it on against normative acts or measures to be taken vis-à-vis businesses. This is true not only for the physical or legal persons across the three countries, but any country in the world acting within this territory. And we have cases against China or Belgium, you name it. And this way, it appears that protection only appears after you have referred to court. But as you exceed the WTO, as we talked through the customs union, there is Article 10 saying, I'm talking now about bad things because of the fight of the two trends, supranationalism versus intergovernmental collaboration. We have the commitment in the WTO that whatever the measure is taken by the Eurasian Commission, it can be appealed against not in the national court. National courts are not valid there, but only to the common court, and it's called the Eurasian Court. That court is specified, and every national court must ask the Eurasian Court, as they address the case, whether or not I'm going to infringe on the conditions of the treaty or accession treaty. I recommend you to read the conditions of Russia's accession to the WTO. They must do it, and against that, national courts start to fight about that because they are not willing to ask. They don't have a habit like this. And court judges are not accustomed to doing that as well, because it's very difficult to combine a universal and regional pieces of law. So those fairy tales about the hierarchy, they sound funny. What about the hierarchy in the UN chart or the statute of the court? What kind of hierarchy there could be? The general accepted principles stand the highest. So what is position in the treaty would go next, not first and foremost. And the court will have to prioritize the universal principles because it was our version of the court that was accepted, starting with general principles of law, that it is the supreme thing. So it happens, so it appears that in order to smooth things out, if only with scandals, but the purpose of integration is to protect the people, to improve the lives according to the preamble of the document. In order to make that happen, you need that working well in conjunction the supranational court and national courts. The way it is done vis-à-vis Luxembourg and Strasbourg. So this link has been split. And listen how those things, nasty things, were made. They added a new article, distorted, radically distorted, but it cannot be killed because the Universal WTO Treaty says differently. They put it went like this, that it is up to the Ministries of Foreign Affairs to decide about the coordination through the court, filing requests, and we would be given a list by the Ministries of Foreign Affairs who is eligible to refer to us. Well, let's wait and see what kind of list they would submit, because you cannot possibly eliminate the court from the list, because if you do, then it means that, well, amazing things were done. If national decisions were against someone, then that someone would file the damage to our court, then in between they would have to run to Strasbourg, referring to Article 1. For the Russian Federation, that would mean huge pecuniary implications, but no one thinks about it. They only think about making the courts weaker, and the Ministries of Foreign Affairs or the Ministries of Justice would have the right to say who should be eligible and who is not. I'm talking about Article 1 that was pushed through because they actually didn't have any desire to have a strong court in place able to interpret these treaties. But without such a court in place, no integration is possible. Another nasty thing, the most dangerous one, is that because this linkage between national and supranational courts is the precondition of our WTO accession. So that needs to be overcome. I don't think it's going to be that bad, because even in the EU, the court gives recommendations. It's only that anyone is eligible to go to court, but there is no norm to asking permission from the Ministry of Foreign Affairs through diplomatic channels. So I think that would be overcome by the protocol at the early stage of the development of the Union. Another very interesting thing that is feasible to overcome, that was a novelty to that nicely worded thing, by the way. So they pushed through that it's not only up to the court to interpret the treaties, but also not excluded is joint interpretation by the member states of the respective treaty. Can you give me a name of anybody in the member states there who would jointly care to jointly interpret treaties? I don't know who it is. Now I seem to understand that ministries of justice are dreaming about having auxiliary bodies to do interpretation of treaties. This total confusion of executive bodies who would allegedly be able to both execute on laws and interpret them. And that is only up to the court. And the third thing is the funniest or the best of all. We tried really hard, and it was hard. I can tell you for certain that this understanding of the role of the courts in these three member states is not really developed very well. People tend to despise courts, to treat courts disdainfully because of our historical cultural legacy, and it takes time to overcome it. People tend to underestimate the role of the courts in the development of law, and there are very few judges who can be good judges, but still I call on you to read our decisions. At least in Strasbourg, someone asked me, who taught you? Luxembourg suggested me to cooperate, to meet, to consider, to make a joint consideration of a case at least once a year. So they seem to be thinking that they and myself are on par. I'm not trying to disillusion them, but what the executives think is to have no such court in place at all. So they want to introduce this norm. I'm quoting literally: the court shall not change or cancel the norms of law. Next comes some language of ours, ensuing from our decisions that A, we shall specify the date to terminate the decision. That's the deadline for the validity of a decision. We can terminate the action of any norm as from its validity. What do you think? Is it changing or making amendments or cancelling? The very tools of the judiciary have been left in place. So what is going to happen? It should be quite normal. We will do everything we need to do, terminating, specifying, protecting things, protecting people from the abuse by national bodies. And there is another dream of getting rid completely of the judges who had initiated the process. This is what we hear every time, because the main thing is for the executive bodies to decide, and no one dared to touch upon that. I think those of you who are aware what the court is, you understand that. Why don't you care? Why do you care to create a court? Just create somebody with the mandate to generate recommendations. But if you want to create a court who can terminate, who can set the date of termination, whose decision is mandatory for the parties, then you must be aware. No way that you can have this happen. This lying still and doing nothing court will not be there, and if you have this court in place, it will not be a court, and people will suffer, and that is it. So I think the general structure, sooner or later, will find a good equilibrium, and it will operate correctly for the protection of people. I don't care whether or not it happens in my time or after me, because I heard many times, but for you it would have all been pretty good. So don't give a damn. You can change the logic of the you can change things, but the very logic of this document will lead to a situation where this document will provide protection of the people, citizens of the 3 member states, because that is the very basis. Now,
also, another competence I like best is when there's a complicated question, both the Commission and the Minister, and neither a Commission nor a Minister nor even a President may decide it. They must turn to a court in any complicated situation. This is what makes it a common space, and I hope this is going to work finally, although there's an effort by the executive to limit the competence of courts. So I hope it will work in the final analysis. As regards practice, it is known that in 3 instances, the Commission's decision relating to big money and bankruptcies was repealed. In 2 cases, we told the national authorities, you may not do this to your citizens. But in a few cases, we were not able to say anything, because among us there's also a struggle between nationalism and supranationalism, and the court cases were closed because there were parallel opinions in favor of nationalism and against it. This is my special opinion. This is my individual opinion. Finally, I want to say that this process of forming a powerful group only seeking to protect the rights of economic agents, this process is complete, and I think that the documents are very good, and I must thank my colleagues because these documents are good, beautiful, modern. Even those fantasies of mine about an ad hoc group were there, whereas Europeans have only approached the issue of defending the labor rights of international servants. It is only now that they are trying to incorporate this element, but with us, we do have it, and weak as it may be, international officers may be protected by our court. And despite this struggle between the legislative and executive branches, we have finally formed documents that make it an integrational group, and this should help us a lot at the WTO. And there are two cases that have been settled. I think there will be complaints about our decisions filed to the WTO, but I am 100% sure that we are going to win those cases. Thank you very much, Tatiana Nikolaevna. I must say that you cannot fail to notice that this person has become a practitioner after being an academic. I know how much effort she put into this, and now it's the other way around. You are trying to turn practice into science, into theory. Of course, there can be no theory without practice. Questions? Sergey? Thank you very much, Ms. Neshataeva, for your presentation, and my special thanks for your articles in the Zakon journal, which is being disseminated around here. It's an article about the Eurasian Union. This is my question. What about the treaties concluded earlier by Russia, Belarus, and Kazakhstan with third countries when they begin to contradict the Eurasian Economic Union? The European Union has faced that, and they have agreed that the pacta sunt servanda principle is no longer in effect because the European Union is the supreme body. And I'm afraid that we're going to face the same issue. So what will be your comment? Thank you very much. I want to say that as I worked at the Supreme Court of Commercial Arbitration, I was the most persecuted person as regards tertiary courts. But I read so nasty things about myself written by international law experts that we are doing the wrong way. No, but we cannot do it the same way as the European Union. It was a different way we joined the WTO. Thank God, not the way Brazil did, but our statement was that our reservation was that in case of contradictions, WTO rules will prevail. And we have assumed to watch that, and our courts will watch that. If there's a treaty contradicting those obligations, the treaty should prevail. And when we made the decision, we limited it all and said that only if we find those contradictions. but the human brain and the brain of a international law expert is so structured as to prevent this contradiction from happening. So in every specific case, we're going to deal with it on a case-by-case basis, and we'll settle it in a way as to avoid all kinds of contradictions for our people. We are not going to look at the executive branch's interests, but we will always look at the greater freedoms. And just saying that the right of the Eurasian Union is the supreme principle. We cannot say that, and we only have to wriggle out of this issue of our government having made the WTO rules the prevalent principle. When the European Union emerged, it did not have any WTO then, and it could freely say that we were above everybody. But in practice, it will be the same thing, but we'll word it differently. Are there more questions, or shall we hear experts? Because we are short of time. Any experts willing to take the floor? Dear colleagues, this is Daniel Vinitsky. Dear colleagues, some very interesting issues, I think key issues, have been touched upon relating to the regulatory framework formed. But I would like to emphasize the breadth of and the scope of what will be regulated by the treaty signed May 29th with all its annexes. The government economy, the financial sector, the services, they are all to be regulated. So the issue we are discussing now about the bodies competent to make decisions and the decision-making mechanisms are indeed key issues, not only in terms of law, but also in terms of economic consequences. As regards this interesting and key issue that we are discussing here today, we could look at it from several viewpoints. On the one hand, it's the confrontation of national and supranational law. Also, within any integration process, there can be positive and negative integration, or the dismantling of barriers to a common market, and it's also a sphere for courts and integration authorities. I would like to follow up on what Ms. Neshataeva said. It's not only a struggle between concepts, but certain opponents of the integration law as a variety of supranational law, I think they fail to take into account the global tendencies of today's world. I am not going to touch on the academic aspects of the issue. You can all read the series of publications issued under the auspices of the American Society and those principles that are being implemented. The financial and tax sector are really the closest to the issue. And that the so-called BEPS plan has been approved as part of the Global Fiscal Transparency Forum in order to fight the erosion of the tax base with movement of revenues by global corporations. We know that a rule is coming into force according to which, in fact, everybody is reportable to the U.S. Revenue Administration, and this is a concept of supranationalism that can be promoted unilaterally. And here, the European Economic Community has no other option. Either it's a combination of sovereignty, it's a combined sovereignty and recognition of a regulation system as a supranational one, with the court having the competence to protect essential rights associated with the with the free movement of goods, labor, and capital, or these instruments are going to be formed, but without the participation of Russia, Kazakhstan, or Belarus. And what is noteworthy here is that many provisions of the treaty and legal framework are aimed at shattering the weakening of the jurisdiction bodies, especially as regards Article 49 of the Statute of Courts. One should realize that without a court being able to form regulatory mechanisms based on precedent, you cannot possibly assure fundamental freedoms and ultimately make agents the end users of legal regulation, and to make them the center of this legal regulation. The experience of our work with the entrepreneurial community, the Eurasian Economic Commission has held joint forums and sent inquiries to economic agents, which indicated how numerous various restrictions are limiting the fundamental freedoms at the level of the Eurasian Economic Community. Sometimes these restrictions look technical. For example, an electronic system makes it impossible to record the nationality of a party and other technical issues that you could not possibly prescribe in the contracts and treaties, and if we don't have, unless we have an efficient body of justice and an efficient judicial authority, the efficiency of legal regulation is reduced considerably. Another thing I wouldn't really dismiss here is that no integration procedure can be carried out by regulation while sitting in offices. Life is always more multifaceted. So if we take the experience of courts in the EU and the Latin American integratory bodies taking shape, you will see that these issues often remain unresolved, and the effect of calling attention is also important when law firms work to promote this EU law to make it a tool of legal regulation. Now, big business is global. It can choose any jurisdiction, English law, German law, Swedish law, no matter how much we restrict it. They are not tied to their place of operation, or only to a certain extent. So in this area of free competition, it is what is up to courts or arbitration committees. Otherwise, global decisions to protect the entrepreneurs will be confronted by the media raising a hype over EU authorities prohibiting a certain type of goods like ladies' lingerie or sneakers. And if we have the precedents as the motive force of integration, then the media, which we cannot ignore, will attract attention to those issues. Another important thing, factor or point raised is the interaction of various legal systems and jurisdictions. I'm concluding. I just want to say this is not a new problem, and the European Union, apart from the EU court, they have the Benelux court or the Economic Freedom Court with different competences. So the idea of legal pluralism has taken shape when there's no direct subordination. I think all these issues are solvable. Thank you. Anyone else? Professor Lomagin, I would like to raise a few points about the peculiarities of the Eurasian Economic Union, and this is something Ms. Nishataeva has discussed. This integration group has to incorporate itself in the existing system of economic relations, considering either membership of the WTO of one of the members or the intention of other members to access to it. So Russia's obligations in the WTO are very important. Out of the three members of the Eurasian Economic Union, Russia alone is a member of the WTO. So one of the key issues will be to form a single external tariff, and also in the context of Armenia and Kazakhstan joining. We all remember that Russia's accession to the WTO continued for 18 years. Armenia conducted negotiations for 2.5 years, but no serious measures of protection have been taken. So the hard work that's in store for us is to convince the WTO partners that this integration group can retain this high level of protection for the Eurasian economic space, let alone the fact that Armenia's accession to the Union will mean a leap across a few integration phases, let alone the issue of Nagorno-Karabakh and the open border with Iran, and the transit of Iranian goods across Armenia's borders. So it's a very serious political issue what the terms will be for Armenia's accession. We should also remember the asymmetry of economic benefits for member countries. It's not reunification or a unification of similar sized economies. When we need to think what the price will be, every country is going to pay for the maintenance of this integration group. We realize perfectly well this is not a linear process. It's not a process of direct increase in well-being. There might be fallbacks and downward trends. There's a lot of skepticism, and Ms. Neshataeva has rightly pointed out that supranational elements may become connecting factors in consolidating this union, but we cannot yet see it as well-formed supranational institution. Another problem is that our partners in the West are unwilling to recognize the fact of this integration, of this alliance existing, and this plays the key role in how they're going to treat the single external tariff. The fact itself that the Union Treaty has been signed is a very important phenomenon, but there is a long process to complete, especially in terms of its interaction with the WTO. Thank you. Now, Viktor Spassky. If you permit me, I am not going to make my prepared presentation. We are very short of time. Just a few brief comments. All the previous parties made their comments as parties or members or commented externally, and I would like to give you a few comments from the inside. We have worked on this document at the Eurasian Economic Commission, and indeed tremendous work has been done, and a very serious international treaty has been prepared, which determines the principles of economic life in the territory of the Eurasian Economic Union. Actual work on the document began only in February 2012, when the Eurasian Economic Commission was set up and when the research had been carried out to codify international experiences. And in late October 2012, we sent the first draft treaty for the parties to consider. New versions were drawn up 7 times, and this work involved 700 experts in the 3 countries and the entire staff of the Eurasian Economic Commission, and some 250 meetings were held. Presidents received 8 reports, vice premiers, 18 reports. I'm mentioning this because you are not going to read these figures anywhere. And then also, if we had not reported the results of our negotiations directly to the presidents, it's very unlikely that we would have been able to coordinate these national and supranational issues. It's a rather thick document, 1,014 pages, and it's structurally convenient for lawyers and businesses. When we decided on the first part of the document, we considered codification issues with 236 international laws on the table. Not all of them are codified, just 68, but with everybody saying codification, I must say this is only part of the process. Another important part of the process is deeper integration. When we began to work on this document, we realized that even the signed documents have left many pressing issues unresolved. And when we asked the presidents, are there many barriers to the 4 freedoms? And the answer was, yes, there are. So do your maths and remove all the barriers. There used to be a few hundred such barriers, but as the documents was negotiated, some 150 barriers were removed. Some other barriers will be removed starting from January 1st, 2015. But what is very important is this. There are some spheres, sensitive spheres, as the pharmaceuticals market, the petrochemicals market, the oil and gas market. It was very difficult to find solutions convenient or good for all the parties. But those common solutions were found. The pharmaceuticals market, the year 2016, the energy power 2019, and then 2025 is the limit for the petroleum products and gas market. It's important for us that we must first the system is that we first develop a concept, then a program, then we draw up an international treaty, and those common markets should start working after being implemented and signed by presidents. So we believed that the principles that these documents had to incorporate were this.
There's a dispute still going on, theoreticians even from the EU, that it cannot be possible. You need to take into account the size of the state, the GDP, the size of population. Our conclusion is only true equality will allow us to move forward, what we discussed before and what we were able to do in the CIS. Equality is first. Next, the treaty should only be an economic treaty as opposed to the EU or Lisbon. Nothing about security or defense. And most importantly, as the drafting was being done, the principle number 3 was working while tapping from best international standards and within the framework of the WTO. So the path that the EU took 25 years, we have signed it de jure and de facto. We're going to make it in 5 years' time. Why? Because we looked at their achievements and the main thing, and most importantly, what they failed in. I don't have time to elaborate on that. But this principle of equality is included in the treaty so explicitly and clearly that even it states that at the level of officials or department directors, equal representation of each member state is provided. Well, yes. What is not the case today? Today it's open competition. For you to better understand the specific features of this draft, Principle 1. Ongoing standing committee as a regulating body with supranational functions, the first ever thing in the treaty. As of January 1st, 2015, the Union becomes the subject of international law. We are not yet. This is why the Eurasian Economic Commission only signs the memos. As from January 1st, it will change. Principle number 2, also important, the one I mentioned before, full equality and taking into account the interests across the levels, presidents, prime ministers, vice premiers. The consensus must be provided. At the collegiate level, a qualified majority, 2/3, some cases could that come from the top will also be voted by the consensus, where we're different from the EU. In the EU Council, for instance, there is a weighted number of votes. Germany has 29, Malta 3. We have equal votes. Next principle is also very important. All officials will be hired through open competition from the citizens of the member states. We didn't have it before. The next principle is, in order to make less mistakes in supranational functions, we have 18 advisory boards in each specialist area, which is important, where the representatives of line ministries, independent experts, and business community will be represented, like transportation, industrial policy, you name it. And according to our regulations, we will not consider anything unless we have had the opinion of the advisory board. Our decision could be different, but we must first hear the opinion of the advisors, consultants. And also we understood that we need to take advice from businesses, because our function is to provide for proper economic activity of entrepreneurs and the states, and to prove competitiveness of the economies of the member states. And for that we have the ongoing dialogue with the business community. So we give our draft decisions to businesses for criticism or review, because it will be a direct action document. Whether or not it can have a negative impact, it works. It works on technical regulations, sanitary norms. Once the treaty is signed, this assessment of the regulatory impact assessment will widen. I'm responding to the question whether or not the respective regulation is going to be developed. It will, and we will work according to that. Next. Another principle I mentioned, we work in line with the WTO norms. So, Kazakhstan and Belarus too are accustomed to working along the WTO norms in their customs regime. Well, once the document is signed and ratified, this is the only document we can leave off. It is easy to read. Structurally, it is a well-written document, but the document states that in the near future, we are supposed to draft several dozen pieces of secondary legislation, which is another big chunk of work, including concepts, international treaties, so the work doesn't stop here, especially for eliminating the barriers. And as I was describing here, one of the components of the deepening of the integration, the second one, the possibility of enlarging. Much is being written about that in the media, and a lot of lies are written about that. It states how you can come a member state, how you can join as a member state or as a supervisor. We have actually 2 candidates to join the Union. At this time, Armenia enjoys very high chances to do it quickly. Next week, vice prime ministers would consider the final version of the draft of Armenia's exceeding the Eurasian economic space as from January 1st next. There was a roadmap successfully implemented for that, so we can take up another stage of accession. It's slightly different with Kyrgyz Republic. They took a long time to consider the roadmap and discuss it in the parliament. It's been approved by the president. On the 29th of March, there was the statement by the 4 presidents about the accession. I'm highlighting the word accession of the Republic of Kyrgyzstan, not only to the single economic space and the customs union, but to the union as a whole. These are the things as they stand right now. The media write that some other countries would love to join the customs union. It is not entirely correct. Vietnam or New Zealand are in talks about a free trade zone with the customs union, which is quite a different level of integration, as well as Israel and India. There were some appeals, and a joint research group was supposed to be formed with Israel and India, and only once they have provided their opinion, only then we can discuss the possible formation of the free trade zone with them. To conclude, I think that economically, this has been a very serious, a major step forward, which brings about real-life results for the economic development of the 3 member states, and there are chances for this project to be a success indeed. While responding to the ideas and desires behind the project. It's been, this project is 20 years now, but it really started actively after the economic crisis of 2008 and 9, because it was about survival of the economies of the 3 countries. The results have been positive so far, and the prospects look good. I think the project will be a success. Thank you for your time. Thank you, Viktor Valentinovich. Well, I'll try not to abuse the lunchtime. Well, I'm the one responsible for the time limit, so we are not being driven away from this. So we can stay. Well, apart from my academic and teaching activity, I find myself in a situation where I'm the only one representative of the business community on this panel. So just a few words to share my summary vision of the assessment of the current developments. And of course, talking generally, as we live in a constantly changing legal regulation, as rules and approaches change so often, whatever we declare on paper with facilitating, simplifying things, making the norms better, there's a whole gap from that to enforcement. And for businesses, for the business community, that's a huge load. Living in an interesting time, living through a transition period when you have to analyze lots of new provisions and legal principles, and you have to make analysis of that, and you have to be in constant dialogue with the regulators who are in charge of enforcement. And quite often, because the new things are new, we face a difference of interpretation. And even if a document is of high quality indeed, until the time when the business community and the regulator have come to a well-balanced common approach, a lot of effort will have to apply. Another thing to mention, yes, we're talking about some competition of the national norms versus supranational norms and their competition with the norms of international law. There's another virtual problem. This is a virtual problem for businesses, but apart from the competitions going on in the legal sphere, there is another competition of the economies. By and large, we have been intensely and quickly moving towards integration, more and more detailed integration. Still, if you look at formal aspects, we're still not cancelling the presidency as a principle, which prevents us from conducting economic activity irrespective the residency principle, irrespective of the place of residence of the economic agent. So even those wonderful institutions that have been enacted on paper, they do not allow the businesses from absolutely freely moving across the borders and barriers as they do business. And I keep hearing from various public speeches and from the members of the Eurasian Commission that we're very far from moving away from the residency principle, because for that we need to have unified not only the customs regulation but also the matters of tax regulation and foreign exchange regulation and a host of other problems. What about joining of new member states? I understand the equality principle that is currently specified, included in the treaty. It could cause some staffing changes at the level of the Eurasian Commission. If as we add one or two more member states, we understand we need to provide their representation on the Commission as well. On behalf of the business community, I would like also to mention that we should be very cautious as we look at the timing as seen by individual member countries. I mean the accession of new countries on the border of Armenia, the Iranian factors so-called on the Armenian border, and there is the Chinese factor, because we understand that we will need to open the border between Kyrgyzstan and Kazakhstan. We would have to be very cautious as we consider these things, and we need to ponder well on the timeline for eliminating the customs legalization and customs clearance, because otherwise it could be detrimental to the economies of the member states. And the last thing, indeed, we're moving consistently towards eliminating the barriers, but a situation where we see lack of balance in the approaches, maybe in the Republic of Belarus in the first place, as we see today that once the treaty has been signed, that state has moved away from the principle of authorized importers. Still, some approaches that we can see in the drafts presented by the Republic of Belarus and the draft pieces of their legislation, some of them are really contradictory to this treaty in terms of the unity of the economic space, and contradictory to the commitments that we assumed as we acceded the WTO. As any party, any member state introduces any restrictive regulations, then by and large the supremacy of the WTO regulations is in contradiction. And there is also the subsidies agreements stipulating the national regime. As of today, all such measures have to be assessed, checked for compliance regarding subsidies and compensations, because it may be difficult to directly monetize, but the very essence of such limitations generate a situation where economic agents appear to be unequal. with some preferences created for some businesses over the others. So these are the problems that I'd like to highlight at this time. And of course, I need to mention that at the level of the Commission, this work and with involvement of experts, and we're working actively on the drafting of the new version of the customs code of the Eurasian Union. And there are new institutions to be incorporated there, and I see how intensely the business community has been involved in doing this work. The experts, even apart from the advisory boards mentioned before, at the level of the Commission itself, the so-called working groups are being created in a whole number of areas, and I would like to call on businesses to get more active, more intensely active, and to try to insist on their stances. Thank you. Thank you. Wilhelmina Pranovna. Well, we've run out of time, but maybe there's someone who wants to ask a question or has kept a final remark for last moment. If I may, I'm not authorized to make a closing remark, but just one brief word. I think this session has been interesting enough. And this is another evidence that on the margin of the St. Petersburg Economic Forum, there are very interesting and exciting problems that are worthy of discussion, very practical, down to earth. As for integration, we seem to have opened a new page, turned a new page, perhaps. It's not a mere chance that any such large and promising project would imply finding the common ground, but also taking care of national interest, and every member state is taking care of its own national interest. Although, according to theory, and we know that from the Western experience, all countries that get together in a union try to find common interests. The common interest is not an abstract thing. It is a very difficult thing to find, to be obtained through compromises and collisions and fights. Secondly, if I were to follow up on this matter, since the transition from one international organization happened through another international organization, the Customs Union and the Single Economic Space, I mean, as full-fledged international, supranational or semi-supranational organizations, it's quite obvious still that all the natural differences of interests or contradictions between various bodies within the Union, these are quite natural developments. Integration is not easy. It comes at a price, and there are many, many large interests and problems to be addressed. What I want to say is that, in theory, as you are defending a thesis, like the one I remember about giving away the sovereignty, many people would oppose to that in theory, but in practice, that is not so easy to give away your national sovereignty to supranational bodies. Like we have all things of our own. It's very difficult to accept people from the outside. It is difficult, we have to admit that. As for the independent judiciary, I think a serious competitive advantage of the Eurasian Economic Union would be if we really have such the judiciary in place. Because it's not only competition in politics or leaders or lifestyles or way of thinking, but competition of jurisdictions that goes on in the world, and having high confidence in such an independent court would mean a lot. I just came from another conference with the European Association of International Law held in Tallinn, Estonia. One of our colleagues, an international lawyer from Italy, spoke there. He criticized the way he understood it, our treaty basis and the institutional structure, but he could not criticize, according to what he said. The most interesting thing that I saw there, he said, was the court in this nascent organization. That sounded really important for me. That is indeed that comes across the borders. I recall another situation where the celebration was held in Minsk of the 10 years of the court. I spoke there to say it was not court but a consultative body, and someone corrected me. International courts should never make mandatory decisions because national sovereignty must be obeyed. I said no, there are international courts who make mandatory decisions, and maybe we're approaching that. And the problems that Tatiana Nikolaevna correctly pointed out, if there are some basic things incorporated, there is a chance and a hope that integration will not only be the right as generated by the legislator and the executive branch, but also to be finalized and taken care of by the courts. This new generation of international lawyers do understand there's no other way of doing this. And Sergei Vladimirovich raised an interesting subject about the relation between the European general law and general international law. Currently in Europe, there's a clear trend towards isolation of the legal system of the EU from the general international law, and there's some logic to it, not only vis-à-vis the WTO, although they strictly compliant with the UN principles. At the same time, they have another concept, like Mr. Kemper spoke about that, the former chairman, of the Europeization of international law. Not to make the European law predominant in the world, but they want to clear a place for themselves to say that there is the European international law, and from their theoretical standpoint, not judicial but theoretical, it should have supremacy over international law with few exceptions. What kind of exceptions? The things that are subject to regulation by the two treaties about the EU, and they have the predominant competence of their bodies. Other issues, other cases, are subject to general international law, all right. And we need to understand, I agree, legal culture is different, and the understanding of integration is different between these countries, but we need to understand the processes going on out there. It is a must. I think we've got a significant impetus for further integration. Integration is just starting, and for practitioners there's much to be done, and for theoreticians as well, as we think and move on and defend our theses and write in books. And I try to be optimistic, as I say. Thank you to all, and my special thank you goes to Tatiana Nikolaevna. She's the only panelist who has remained until the last moment. And why you are still here, Elvira, and our second speaker and our wonderful experts. Thank you. This is adjourned.